Um, going to read Chapter 2, the nature and scope of due process. The applicability of the Bill of Rights to the states, starting with Section 1, which is the fundamental rights in incorporation. The first 8 amendments were enacted as limitations solely upon the federal government, but some argued that the 14th Amendment had totally incorporated all of the provisions of the Bill of Rights, i.e., made them fully applicable to a series of rulings spread over several decades rejected this total incorporation interpretation of the 14th Amendment, although the court was often divided, including one 5-4 ruling. Instead, the court adopted what has been called the fundamental rights or ordered liberty interpretation of the 14th Amendment due process clause, an approach that prevailed until the early 1960s. This approach finds no necessary relationship between the content of the 14th Amendment and the guarantees of the Bill of Rights. It regards the due process clause as simply incorporating all principles of justice implicit in the concept of ordered liberty or so rooted in the traditions and conscience of our people as to be ranked as fundamental. As applied to criminal procedure, this approach only that the state afford a defendant that fundamental fairness essential to the very concept of justice. This standard could encompass all, some, or none of the protection that a Bill of Rights guarantee provided against federal government action. As Justice Harlan observed, page 40, the key is not that the particular protection has been found in the Bill of Rights, but that it was deemed fundamental. While the presence of the Bill of Rights guarantee is not decisive under this approach, neither is its absence. A particular practice may violate fundamental fairness even though it is not specifically prohibited by the Bill of Rights. As recognized in rulings applying the Fifth Amendment's due process clause, the due process clause of the 14th Amendment has an independent potency. See Frankfurter in ruling in Roshan versus California, page 37. In McDonald versus City of Chicago, the Supreme Court offered a brief review of both the period in which this fundamental fairness approach prevailed and the eventual displacement of that approach with the selective incorporation doctrine. McDonald followed District of Columbia versus Heller, where the court had held that the Second Amendment protects the individual's right to keep and bear arms for the purpose of self-defense. The Heller court had struck down a District of Columbia law that banned the possession of handguns in the home. After Heller was decided, petitioners filed a federal suit against the city of Chicago, obtaining that Chicago's handgun ban violated the 14th Amendment. In McDonald, a 5-4 majority agreed. Justice Alito, joined by Roberts and Scalia and Kennedy, reached this conclusion via 14th Amendment incorporation of the Second Amendment under the 14th Amendment's due process clause. Justice Thomas agreed that the Second Amendment is fully applicable to the states, fundamental to the American scheme of ordered liberty, and deeply rooted in the nation's history and tradition. However, he could against the states through a clause that speaks only to process. Instead, he viewed the right to keep and bear arms as a privilege of American citizenship applicable to the states through the 14th Amendment's privileges or immunities. In part, ID of his opinion, speaking for a majority of the court on various cases and 14th Amendment due process. During an earlier era, even when a right set out in the Bill of Rights was held, the conception of due process, the protection or remedies afforded against state infringement sometimes differed from the protection against abridgment by the order of the federal government. To give an example, Brady, the court um, although required the appointment of counsel in all federal cases in which the defendant was unable to retain an attorney, the due process clause required appointment of counsel in state criminal proceedings only where want of counsel in the particular case resulting in Wolf versus Colorado. The court held that the core of the Fourth Amendment was implicit in the concept of order, liberty, and thus enforceable against of the Bill of Rights. As Justice Black noted, the chief congressional proponents of the and made the Bill of Rights applicable to the state. Nonetheless, the court never has embraced Justice Black's total incorporation theory. While Justice Black's theory was never adopted, the court eventually moved in that direction by initiating what has been called the process of selected incorporation. The court began to hold that the due process clause fully incorporates particular rights contained in the first 8 amendments. Gideon, Malloy versus Hogan, Duncan versus Louisiana. The decisions during this time abandoned 3 of the previously noted characteristics of the earlier period. The court made it clear it's not whether any civil assistance can be a requirement for protection under the Due Process Clause. The court eventually incorporated most of the provisions of the Bill of Rights. Only a handful of the Bill of Rights protection incorporated. So, there's a couple of theories I'm going to underline. Total incorporation, whereas selective incorporation is what seems to have taken place after 1960. I'm going to check all of these cases, keynote cases, and I'm gonna do that list. You may come up in this book. That's verse Brady. Well, first Colorado. Um, Heller, McDonald. Now, for the selective incorporation, there was a different approach. Do you want to